Mr. Khadr's sentence has been frozen in time for about 3.5 years now, and essentially we just want the clock to at least start ticking again. We want Mr. Khadr's sentence to start ticking so that it will eventually end. And further, we suggest that the sentence has already been served, and so we think it should end now. We don't want Mr. Khadr to have the threat of jail over his head any longer, and so we wish to ensure that what remains of his sentence is not going to be a jail sentence, it's going to be a sentence of conditional release. There's never been any basis to believe that Mr. Khadr is a threat to anyone or that he needs to be imprisoned any further. Anyone, including federal correctional authorities who have dealt with him, all universally agree that that he should not be imprisoned and that he should be released. And so it is good to hear, but it's not surprising to us, and it's what they've been saying for a long time now.
So the CMCR, which is staffed primarily by military judges, over our objection, immediately bifurcated the case, put the merits on hold, and said, we want the parties to brief whether this appeal has been waived. So we objected to that, but we didn't have any choice, so we did that. That decision has not yet been made.
6 years later.
6 years later. And I was directed that I was not allowed to file anything until further order of the court, and that it was going to be held pending the decision in another military commission case. The only thing that we can do is to urge the CMCR to lift the abeyance order and begin to litigate the case again. We may well have some good arguments on the merits of why these are invalid convictions, and they would rather not confront that.